Okay, so let's get started. We have a busy agenda tonight, and as you know, my name is Annette Hines, and I am a special needs attorney, which is a very small, little niche market. It's pretty narrow focus for an attorney, and this is all that I have ever done. I've only ever been a special needs attorney, and I've done it for a really long time, over 2 decades, which makes me feel quite ancient. But but I am really, really experienced. That's what that means. You know, I'm really experienced. Yes. So when I say a special needs attorney, that means that we are well-rounded. We don't just do special needs trusts. We don't just do guardianships. We do everything special needs. And so we're going to talk about guardianship tonight. And then we're going to touch on some other subjects as well. We're going to talk about ABLE accounts, and then we're going to have a question and answer session, and we're going to let you ask me anything turning 22 or transition based. So you can ask me about housing, you can ask me about employment, you can ask me about Social Security or Mass Health, you can ask me about DDS eligibility, ask me anything that's on your mind. And we will talk about it. And if I don't know the answer, I can get it for you. But it's rare that somebody stumps me. So I'm going to challenge you to try to stump me tonight, okay? Because it is rare. It is rare. Now, if you ask me a question about, you know, what is the dollar figure for blah, 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 I might not remember what that dollar figure is because, you know, I am really getting up there in age, and I don't always remember what those dollar figures are. If you ask me what the statutory reference is for something, I'm not going to remember that. But if you ask me a question about how something works, you know, and what this means for you in real life, I will almost certainly be able to answer all of those questions. So if you have your agenda, we're going to spend about 45 minutes talking about guardianship. And when I say talking about guardianship, this is not going to be your typical, I'm going to tell you what guardianship is all about. I'm going to actually walk you through how to pursue guardianship and how to get it done, okay? So we're going to talk through the whole, you know, petitioning system. And then we're going to spend 15 minutes talking about ABLE accounts, and then we'll go into our Q&A session. I'd like to take your guardianship questions during the guardianship session, and then, you know, switch gears to the ABLE account session and so on and so on. If we can kind of stick to each topic, it'll make the video better if we do it that way, so that we can keep the videos in their topic for everybody. Does that make sense? Okay. All right. So your guardianship process handout is right here. And if we could follow along with this, this is what we're going to talk about first. So let's talk about the guardianship process in Massachusetts. What is guardianship? Guardianship is when we have to pursue the ability legally to make decisions for another adult in our state. And in our state, and in every state, that can only be done legally by pursuing the authority in court. And a judge needs to sign a court order which does 2 things. Declares incapacity at some level, doesn't have to be full incapacity, can be partial, and assigns a person to make those decisions. In other words, assigns a guardian to make those decisions. So those 2 pieces have to get met in court, and only a judge in each jurisdiction, in each state, can do that. So the process may differ from state to state, and the evidence that needs to be presented may differ from state to state, but ultimately the decision maker is the same, and the result is always going to be the same. So your decision, though, is whether to pursue guardianship or not. And that's where you start. That's the beginning for every family and every conversation, as your child is, you know, getting close to age 18. And why is age 18 so important? It's important because that's the age of majority in our state. And that means that the minute that they have their 18th birthday, they are assumed to be competent and have capacity to make their own decisions. It does not matter if they are extremely incapacitated. My daughter Elizabeth is a perfect example of this. So my daughter Elizabeth, who, as I mentioned earlier, passed away when she was 17, was somebody who, was on the spectrum, profoundly disabled. She was in a wheelchair and she was blind and she had a profound brain injury. And so she was unable to speak and was not able to, really make her wishes known very well. And so you would have looked at her and said, clearly she needs a guardian. But if we had not gone to court and pursued guardianship for her when she turned 18, she would have needed to sign her own documents and would not have had somebody in a position of authority to be able to make decisions for her. So a judge would still have had to assign by a court order a guardian for her and would have still had to make the decision that she was incapacitated and over what areas of incapacity decisions were going to be made. So there is no automatic. It does need to be determined in court. So you as a family need to sit down and start talking through some of those decisions. For most families, they're not in the same boat that I was. It's not immediately clear. There's some discussion that needs to be had. Is guardianship right for us? Is it right for right now? Is it right for our situation? And some of the factors that you need to think about are what is going on right now in my child's decision-making ability, and not what can they do with my support, but what would they be able to do if I wasn't here? Would I be able to plop them down as an 18-year-old in their own place, and would they be able to take care of some of the basic necessities of life? With some support, yes. But think about a child that you send off to college, for example. Would they be able to make the same basic decisions as your child that you send off to college? Would that child be able to get themselves off to the health center if they had a sore throat and needed to, get their throat checked and make sure that they don't have, some kind of a bacterial strep infection? And if they did, would they be able to then go to the CVS pharmacy and get their medication and then follow the medication prescription and take it until they're well? And, a couple of things like that. Would they be able to advocate for themselves if they needed to? Would they be able to make some decisions about other things like, can they manage their finances and manage negotiations to get employed, and just small day-to-day things. So as you're thinking through sort of a short checklist of, day-to-day things, you want to think about things in a continuum. It's not going to be perfect, and you need to kind of think about how much support and help for each area does your person need in order to be able to make decisions. And then you need to look at whether guardianship is appropriate. And then what kind of guardianship are we talking about, limited or full? So that's the beginning. Once you're deciding and you're leaning towards guardianship, then we have to talk about how we start that guardianship process. And when is the ideal time to start that guardianship process, right? Because a lot of people do have questions about when they should start the guardianship process. And really, you probably want to think about when to start the guardianship process based on how difficult it's going to be to get your medical evidence. So I think I'm going to defer that when to start until I get into the process a little bit. So I'm going to come back to that question. Generally, I usually answer that with about, you probably want to start about 6 months out, but it could be a little bit closer to the 18th birthday, depending on what your medical evidence is that you're going to need. So we'll come back to that question in just a little bit. So every single court case starts with a petition. Your petition is, you're asking the court to do something. You need to plead, that's what a petition is, it's a pleading to the court, which is asking the court to give you relief or to do something for you. So your petition needs to lay out your request to the court. And in that petition, you need to not only request guardianship, but you need to also state who you want to be appointed as the guardian. So along with that petition, though, you're going to be submitting your evidence of why you think guardianship is needed. And your evidence needs to be submitted on the court's form. And this medical evidence is where we come back to how early do we need to get started, because medical evidence in our state is split up into two different kinds of, two different forms, and it depends on what you're pleading for your medical evidence, what condition your person has. So if you are claiming that the person needing guardianship has an intellectual disability in our state, you can only use a clinical team report. You must use a clinical team report. And when you have your petition, you check a box that says, does this person have an intellectual disability? That keys the court to look for the right medical evidence form, that clinical team report. So they will know that if you haven't submitted the right form, it doesn't match up. So they're going to look for that matching clinical team report form. This clinical team report form has certain rules that go with it. And the rules can get confusing. So I'm going to tell you what they are, and then we'll repeat those again, just so we get them straight. So these rules are very different from the other kind of medical evidence. So the clinical team report has some really good things about it and some not so good things about it. On the good side, this form is good for 6 months, which is great because it means that you can take your time, and it does take some time to get this form filled out because you need 3 clinicians. That's one of the tough things about it. With an intellectual disability, the actual medical definition on the DSM-5 of intellectual disability means that it must have started in childhood. That's the only way you can have an intellectual disability, is if it started in childhood. So intellectual disability is a permanent condition. It's a lifelong condition. It is unlike other types of conditions. So intellectual disability must be proven by 3 different types of clinicians. And they're written out on the form who can sign it, and they're written out also in the statute as well. But just for briefness today, the people on the form that can sign it, that must sign it, are a licensed psychologist, a licensed physician, and a licensed social worker. there's a lot of questions about who that licensed psychologist can be and who that licensed social worker can be. And we can, answer some questions about, can it be somebody from the school system? Can it be somebody, in my town? Essentially, it needs to be somebody who is treating your child. Treating only means that they have to have an appointment with your child. So here's a question that I get very, very often. Does that mean that my child needs to have an evaluation to determine whether they need guardianship? The answer is no, they do not need to have a full evaluation to determine if they need guardianship. They only need to be seen by somebody who has a relationship with them. Or alternatively, they can be seen by somebody who can rely on the records. They can do a record review and who works with the team that sees them. So let me give you an example. Sometimes we have people who, they might have 2 out of 3. And there might be a social worker within the practice, but that social worker has never seen your child before. However, the physician knows your child really well, and the social worker knows the physician really well. So the social worker can have an appointment with the child and rely on the records that are in the medical record and speak with the physician and feel quite comfortable. The physician fills out the form and the social worker signs off on it with the date that she had or he had an appointment with the child. That works very well. They can also clinically bill for that as a visit, as a medical visit. So that works out well. That happens sometimes with psychologists as well. So it's getting tougher and tougher to pull together a clinical team. And we are having a lot of folks refuse to do this work. A lot of people are having to private pay hundreds, sometimes thousands of dollars to get these forms filled out. Thank goodness you only have to do it once, except now we're having to do them if you're making changes at all to your guardianships. We are having to go back and get new clinical team reports. We never used to have to do that before. Once you had a clinical team report done, it was done. I will tell you that DDS, when they go back in to do stuff for you later on, and this is sort of getting a little bit ahead of myself in the talk, they can sometimes be somewhat successful in getting those clinical team reports waived. But again, for the most part, those clinical team reports, when you go for the guardianship, you've just got to do it that one time. So you need to do whatever you need to do to get a clinical team report filled out. And just be prepared that if you don't have a clinical team that meets the criteria, you're going to have to seek one out. So in that case, if you have a person with an intellectual disability, then you need to be ahead of the game and get started early enough. And 6 months may be enough time for you to start working on this guardianship process, but it may not be. So you want to be thinking about that before you start getting your guardianship together, okay? So that's why I wanted to revisit the time frame of when do you get started. On the other hand, if you are looking at anybody who does not have an intellectual disability, maybe you have somebody with another neurodiverse, issue, autism, or another diagnosis, or physical challenges, or somebody with a low incidence disability who is deaf or blind, or medical complications or mental illness, some other challenges like that, then we're going to be using a medical certificate. And medical certificates are easier to fill out because they only require a physician. And actually, there are some categories of other folks who can fill them out, like nurse practitioners and so forth. But they're only good for 30 days. So you have to actually get one when you file, and then you need another one right before you go to court because they expire before you can get back to court. And you need to use the same person. So don't go to that neurologist who knows your child so well, but who you can only get an appointment with every 8 months because they take so long to get an appointment with. So you've got to think that through because you need to get that second one filled out. And you can only get one filled out on appointment. You have to have an appointment, even if your child gets seen for 2 minutes. They have to have an appointment date on the books for the day that you get the report done. So that medical certificate requires a new exam date, okay? So again, it's all strategy and it's all schedules. But my parents, you have been doing this for 17, 18 years. You've got this all down already. You already know how to figure this all out. So if you're given the rules ahead of time and somebody tells you what you need to get done, you can do it, right? Right? Yeah, of course. So, so this is just another piece of the puzzle. And, you know, I didn't say this in the beginning, but I will tell you now, and we can talk about this again. You are not required to have an attorney to file your guardianship. I'm sure you know many people who've done this on their own. Some people do get attorneys, and you know there are reasons to have an attorney represent you, and we'll talk about that at the end. But many people do successfully represent themselves. This process is challenging, make no mistake, and it gets harder every year. But it is not impossible to do this on your own, and that's why we give talks like this, to help people to get the information out and to help people overcome the hurdles of, you know, pursuing guardianship on their own. Okay? What if they are not documented before the age of 3? It doesn't matter, as long as they've gotten a diagnosis before you are going to court at age 17 and a half. So that happens a lot, right? Not everybody has autism. So, you know, the documentation for any diagnosis could happen at any point along the way. So it's really what is going on at the time that you are pursuing the guardianship. So that's what we really care about. That's what the judge is going to care about. That may be a different story when you are pursuing supports for other public benefits. So we should come back to that question when it comes time to talk about public benefits. In our state, we don't have what's known as standby guardians. So unfortunately, we can't, through our court system, set up a process for somebody to step in and take over. So that is a really disappointing factor of our state law. There are many states who have standby guardians, but we don't have that. In your estate planning process, which is really another part of transition planning, and some of the handouts that I brought with me today, I recommend that you strongly look through them. Transition planning is like a three-legged stool, and your estate planning is a very strong part of it because that supports the guardianship process and the selections that you are making. You want to make sure that you have documents in place that nominate under our state law. You, as parents, you have the right to nominate your next guardian. That person or people, unfortunately, still have to go to court. But because you have nominated them, the court must appoint the person or people that you have selected. That is, it's the same court process, but it allows the court to just forget about anybody else that has come forward in case there are multiple candidates, for example, and that can be difficult in certain family structures. So it's really important to have that conversation and get those documents in place. But again, in our state, we don't have legal standby guardians in our guardianship documents in court. So that is a disappointment for us. You can pursue guardianship at any age, and it's better if you pursue it at age 18 if you know a person needs a guardian, because obviously they are supposed to be making their own decisions at the age of majority at 18. But most of the time, people don't get guardianship right away, and there can be some times when people just want to wait and see what happens. As you're having your family discussion about whether this is the right thing to do, you may decide to wait and see for a few years. And we have definitely had many, many cases over the years where people have pursued guardianship a few years in. Usually that's when things aren't going so well. And now we can go to a judge and say, well, we were hoping that we weren't going to need to do guardianship, but judge, here's what's happened. So-and-so has signed himself out of school, or we've had this incident happen, or that's happened, or we're having some difficulty advocating for him or her, or they haven't quite matured in the trajectory that we were expecting or hoping for. So, we are realizing that we need to do guardianship. It's a story. You have to tell the story about why not at 18. If you go at 20 or 21 or 23, that's not so bad. If you come to the judge when somebody's 35, you've got a lot of explaining to do. But that happens too. So, another big transition time for people is really when parents age and the baton gets passed down to siblings or the next generation. A lot of times parents have been able to get by with supported decision making, and doctors and healthcare systems and other systems have let things slide, but they don't feel as comfortable with siblings. And now we need a legal structure around something that we haven't needed before. So that's another story, and the judicial system totally understands that. They see that every week, pretty much every day. So again, it's all about just talking through what's happening at the time and figuring out what the solution is.